morning, everyone. Happy March. So happy to see you today. Welcome you joining today's class. Savor at home and learn. Everything you want to know about vesting descriptions. I'm Pauline Lam from Cotai Realty, your 2021 Co-Chair Education Committee, West and Gabriel Valley Realtors. A friendly reminder, all participants will be muted, and should you have any questions, please text it into the chat box. Sylvia will help the Q&A section and speaker will answer you at that time. This meeting is being recorded and will be available on the YouTube channel, West and Gabriel Valley Realtors. Now, I'm so happy to invite Sylvia Rosage, our 2021 Co-Vice Chair, Education Committee, to introduce you our very special speaker, Ms. Nancy Chen. And right now, Sylvia, it's your time.
Thank you, Pauline. Good morning, everyone, and welcome to our Safer at Home event. This morning we have Nancy Chan. I think we're all very familiar with who she is. If not, then she's with lawyer's title, and you already know all her bios there right before your eyes. And she's here to let us know all the information we need regarding the vesting. And I want to welcome Nancy to our special Safer at Home.
All right. Thank you, Sylvia. Thank you, Pauline, my dear friends. I don't want to say the word old, so we're not old, okay? We are learning continuously. I've been in the business 39 years. Next month will be my 40th year. The business is so amazing, so rewarding that I'm learning all the time. And it's been just wonderful growing and helping other people grow, realtors grow in this industry. The reason I'm talking about vesting is this is one of the most, I get more questions on vesting than anything else. So every day I get a couple people asking me. So that's why I thought this is important, but let me give you a little update. The things that I'm talking about is the way of holding title in California. So if you're talking about other states, this won't apply because we're a country made up of 51 states. We're the United States of America, and recently we know more important, the federal and the state law are completely different. So I want you to understand, this is talking about California. I have people that buying property in Las Vegas, Arizona. They ask me these questions. As a realtor, even if you're licensed in any state, talking about vesting is very sensitive. So I don't want you to give them advice how to take title. If your client have any questions, they're welcome to call me. I don't want you to put yourself in a situation that you're responsible in case something happens. Number one, why? We don't know their family situation. You know, we don't know how many times they've been married. We don't know they have children from past marriages. We don't know the financial situation of the family and their family dynamics. And then we don't know their tax ramifications. So as a realtor, we have this in English, we have this in Chinese, we have it in Spanish. If you want it, we'll send it to you. You can give it to your buyer. And if they have any questions, they should talk to their CPA or their attorney, okay? As an agent, you can explain a little bit, but never ever give them advice, including me. So everything I say is for discussion only. I'm not an attorney, I'm not a CPA, okay? So I'm just giving you explanation of these vestings, okay? That's a disclaimer. And we all are in the business to help our clients, but sometimes helping too much can be a problem. All right, let's start with community property. Community property in the state of California, all husband and wives are community property already. Now we have same-sex marriages, we have domestic partners. Number one, you have to remember, if they're same-sex marriage, they have to be legally married. Or if they're not married, people living together, whether it's male or female, whatever, they have to be registered domestic partner. That has to be legally done to be able to use community property. Does that make sense? Husband and wife automatically in California, it's preempt your community property. But if you're a domestic partner, you need to register legally. If you are same-sex marriage, you have to be legally married, okay, to be able to say it's community property. All right, so community property has to be husband, wife, domestic partner, same-sex marriage. I didn't put it in there, but I should. That's an update. Division of title, they're all equal, okay? So their names are on there, so they both have equal right in the interest. So it's 50-50, all right? They shouldn't be 3 people on title in a community property, okay? Only 2. Married couple, married same-sex or domestic partner. So there's no 3 people in a community property vesting. I want to clarify that. So it's equal. Usually it's 50-50, okay? Title, they have to be in the names of the individual. You cannot put a company or whatever and say community property. It doesn't work. It has to be real people, individual, okay? Possession, equal right of possession. So they have the equal right to use and enjoy this property. And they can go in and out whenever they want to because it's their property. So that's possession, all right? Conveyance, anytime the people want to transfer the title, both spouses, both registered domestic partner, both same-sex marriage, husband and husband, wife and wife, must, the word means must, join in conveyance. That means they have to sign it over to somebody else the same time, okay? They both have to sign. Decedent spouse, the 1/2 is passed to the other person's estate. So if for me, my husband and I, a community property, or you can say husband and wife without saying community property. As long as if you see a deed, it says so-and-so, husband and wife. Let me say John Lee and Christine Lee, husband and wife. Sorry, I'm using the name. If I'm using your name, don't get offended. John Lee, Christine Lee, husband and wife. They didn't say anything about community property or anything in the back. They are presumed community property because California is a community property state. As long as you're married, you don't have to specify community property. You are automatic community property, unless you say something else in the back, like tenants in common, joint tenancy. I will talk about that later. But I'm only talking about 2 people, husband and wife on title, or domestic partner on title, or husband and husband, wife and wife, automatically is community property without saying so. You don't have to write community property in the back of their names. Does that make sense? Because California state is a community property state. All right, so if one party dies as husband and wife, or they say community property, the other person that is living gets the percentage, his percentage. Remember, we talk about 50%. So the person that is still alive gets the whole thing. All right, if you're confused, put it in the chat room and I can explain that later. And there's successor status. That means the person that took over the property when somebody dies. Okay, so they get the whole 1/2 interest past the descendant. Tenants in common between divorcee and survival results. So if okay, the person that is alive gets the whole thing, or if somebody, okay, this is something that we need to talk about. Tenants in common between divorcee and survivor results. So what if, wait, I'm sorry, I got confused. So they don't get the whole thing, only 1/2 gets transferred. I'm sorry, I'm talking about community property with the right survivorship. In this case, only 1/2 of my interest as community passed to my spouse. Does that make sense? So my other half, the person that died, if I die, my one half goes to my spouse. The other half, it's my successor, my kids or whoever. Make sense? That's a little different than community property with the right of survivorship. This one is only community property. So if I only have one son or my father, whoever, that's my successor, okay? They become, let's say it's my son. My son's gets half of mine. That means 1/4 of the property. Because one half of mine is passed to my spouse. So he owns 75% now. My other half of the 100% is 25%, goes to my divorcee, my survivor. I died. My survivor, they become tenants in common. My sons become tenants in common with my husband. This is the difference between community property and the community property with the right of survivorship. That means my husband doesn't get 100% of mine, only one half. The other half, I have a will, or I can will it to somebody. If I only have a child, that one child gets my half. That means 1/4 of the whole estate. So now my son is tenants in common with my husband. Is it confusing already? The first thing I confuse you guys. Successor means I willed it to somebody. I wrote down, okay, I only have one successor. Has nothing to do with my husband, has me. He gets 1/4 of the property. They become tenants in common. Community property, and there's no survivorship anymore. So the husband or the wife gets half of the other person, the other wife or husband that died, and the other half goes to a successor, and that person is tenants in common. So that's why I tell people, when you have community property as husband and wife or domestic partner, or same-sex marriage, you better make sure that you know who that successor is, because otherwise you'll go to probate. So that's why we created, later on, about 15 years ago, we created community property with a right of survivorship. I don't know exactly the year or the date, but that community property with the right of survivorship came in later. We didn't have that. We only have community property, joint tenants, tenants in common. Community property with a right of survivorship came in later, okay? All right, we're talking about creditors because people are afraid that somebody's gonna lien the property. What if I die? I have a lot of debts, I have lawsuit, whatever. Or I own a business, I have a EDD or some kind of tax lien. Community property, the whole property, is liable for all the debts of either spouse incurred before or during the marriage. So if I didn't die until 2021, but I had a tax lien on my nail salon, okay, 2 years ago while I was married, that lien can be put on the property. Make sense? So either party is liable. So when they sell, they have to get rid of that lien. They have to pay off that lien. Am I confusing you again? That means any debt the spouse the spouse have before the marriage and during the marriage, the other spouse is liable using the property the property will have a lien. Before, that's a question I get asked. I got married, so my status changed. So if you marry me, you take my debt, take the good and the bad. Makes sense? So that's why, okay? So I'm not going to confuse you anymore. Let's talk about the community property with the right of survivorship. The difference is the first one is the same. Division is the same. Title is also the same. Both people's name, both the husband and wife or domestic partner has to be in there. Possession is the same. Conveyance is the same. When they want to grant it to somebody else or ask somebody, they have to also do that. They both have to sign. Okay. The death is the difference. If you take community property with the right of survivorship, my successor has no right to the property. My kids or nobody has the right to the property if I die. My whole half, my 50%, goes to my spouse. So now he owns 100% versus the community property he only owns 75% if I die. The first one, half of it, of my property is not his. Only half of it is his. Vice versa. If he dies, I get 75% of the properties. I get my 50% plus his 25%. The other 25 can go to his previous marriage, kids, or whoever. Does that make sense? He can write a will. He can give it to somebody else without my consent. That's a difference between community property and community property with the rights of survivorship. This one I'm talking about, community property with the right of survivorship, the surviving spouse gets the whole thing. Any questions? All right, let me read, you can ask that later on. So community property with the right of survivorship, my whole thing, if I die, goes to my husband. Nobody can say anything unless they want to go sue, but it usually that's not going to happen. Okay. Survivor owns the entire interest. That the spouse that survived, that didn't die, gets 100% of the property because there has survivorship. Creditor's right, same thing. One dies, the other person is liable for the other person's debt. Lawsuits, tax lien, whatever. Okay. Sylvia, do you have any question? You can ask. I think you should, because I think
that the questions, well, posted so far, if you want to go through them, is saying, I think it's Jiwa Che. I think she said hello is, but I think she meant if property is owned before marriage, is it considered as community property?
this is a very tricky question, but it's a very good question. Remember the last one I talked about? Creditor and debts before the marriage becomes part of this, it's liable. That means in California, not other states, prior marriage property automatically becomes community property as soon as you get married.
Wow.
That's why people have prenuptials and all that stuff. So that's another different story. Do not ever advise your client on property they acquired previously. I get this all the time. Well, this is before marriage. Why do you have to have him to sign? Nancy Chan took title as a single woman 15 years ago. Now Nancy Chan wants to sell the property. The husband has to sign. Prior marriage does not work in California. Property purchased prior to marriage is community property automatically. Because why? The state is community property state. As soon as you get married, everything is commingled. Everything is lumped into one. That's a number one thing. I get this all the time. They bought this property before they got married. Well, the state law says as soon as they get married, the spouse automatically has right to everything he owns or she owns. That's why people have prenuptial agreement, right? That's the accountant. That's an attorney's job. If you have a property from previous marriage, you ask me or your client asks you, you really shouldn't give them advice. They should talk to their attorney. A real estate attorney, a good real estate attorney, not just anybody you find that's going to charge you very little, okay? In this industry, price is not a problem. You got to get somebody that's good, that's qualified, all right?
Okay, Now, I have another question from Gina Chen.
Mhm.
She's asking, community property, can a person will their entire half share to successor?
Nope. If you're married, domestic partner, husband, wife, you only can will one half of your share, not the whole thing.
I think she said their entire half.
You can't do the entire house. Your spouse has, remember, conveyances has to be both parties. So if you want to, okay, my husband and I own the property. I want to go and just put it in the will, all of them. No, he has to agree to it. I want to grant it to my parents. I can't. He has to sign in that grantee. You can't do it by yourself. Once you get married, you're liable and he's liable. You're combined as one party.
Okay, noted, she said. Thank
Okay,
you.
very good. All right, let's go to joint tenancy. All
Yes.
right, let's clarify something. Community property and community property with the right of survivorship can only be used for husband and wife, domestic partners, legally registered domestic partner, legally married same-sex marriages, okay? You have to be legally married. But joint tenancy is different. Anybody can be joint tenants. You can be sister and brother, you can, but friends, that's not a good idea. But joint tenancy is very different. In the old days, when I first got into the business, joint tenancy, most people will use joint tenancy for husband and wife. There are still a lot of people that in the old property profile, you see the grantee, they're joint tenancy, husband and wife, joint tenancy, okay? So that's, but it's not just for husband and wife. Anybody can do it, okay? So parties can be any number of persons, can be husband, wife, domestic partner, or it can be just friends. It could be more than two people. It has to be more than one person. So it's 2 people, 3 people, 5 people, 10 people. I've seen title that are like 11 people as joint tenancy. So joint tenancy, the share and division of interest, the key to it. If you're joint tenancy, you will have to have equal share. If there's 3 people, 1/3, 1/3, 1/3. 4 people, 1/4, 1/4, 1/4, 1/4. 10 people, each owns 1/10%. Joint tenancy has to be equal share, and all the people's name has to be on the grantee. Equal right of possession is the same as the community property and community property right of survivorship. Conveyance. If there's, okay, let me give you an example. I have 2 sisters. 3 of us bought a property as joint tenant, okay? And my sister decided she doesn't want to be joint tenant with me anymore. She wants to give it to her son. She signs a grantee, grants it to her son, that 1/3. Guess what? The 3 of us are not, that means me, Nancy Chan, my other sister's name is Sophia, and my other sister is Jane. Jane decided to grant the property to his son, Alvin. So there's Nancy, Sophia, and Alvin now. We're not joint tenants anymore. As soon as one person signs out without the 2 other people on title, it becomes tenants in common. Unless all the sister loves the nephew. So all of us, Nancy, Sophia, Jane, signs a grantee, grant to Nancy, Sophia, and Alvin. 3 people signed the grantee at the same time and specified joint tenant. We can still remain joint tenant. If one person signed off, no more joint tenant. It breaks the joint tenancy. It becomes tenants in common. So I have people that make the mistake. One sister wants to give it to the brother because she got married. She wants to get married, but she still wants, the property was purchased by the parents for the 3 kids. So she still wants the brother to have it because the brother now is 18. Okay, what happens? All 3 of us has to sign a grantee, grants to the 2 of us plus a new person, and also specify all as joint tenants. It has to be one document executed at the same time. notary on the same day to maintain the joint tenancy. It gets complicated, huh? So when they want to do something like that, give me a call. I'll tell you how to do it. Otherwise, it's going to break the joint tenancy. Okay? Conveyance by one co-owner breaks the joint tenancy. They become tenants in common. Even though they're still equal share, 1/3, 1/3, 1/3, no more joint tenancy, automatically breaks it. Even though we didn't see a tenants in common verification, but when the title company looks at the deed, 3 people own it together as joint tenant, now one quick claim to somebody else, even though the other 2 people didn't sign anything, we, in the California law, we know it's no longer joint tenancy, it's tenants in common. So if one person dies, guess what? It goes to probate. No more joint tenancy, okay? Probate attorneys will make money at this time because my sister Jane quitclaimed it to the son 1/3, and if I passed away, mine goes to probate, they don't get it. That defeats the purpose of what our parents wanted. My parents wanted us to share all that stuff that they gave us, the 3 sisters. But now no more. Mine goes to probate. My husband and whoever, whatever they can claim. The kids and, you know, all that stuff, okay? Death. Somebody dies. If 3 people, the 3 of us, I passed away, the other 2 automatically gets my share. So now it's 50-50. So they each own 1/2. Make sense? Because joint tenant has survivorship. All right. So another sister passed away. The 3rd one gets the whole thing because it's joint tenancy. Survivor gets the whole thing. If there's 5 people, 1 person died, it becomes 1/4 interest. Each one owns 1/4 because the 5th person passed away. And then another person died, they all become 1/3, 1/3, 1/3, right? So the last one gets the whole thing. So take care of your health, okay? You want to be the last to go. So the last survivor owns the entire interest. The last one is the important part. Consult your attorney. That's why people take title as corporation and LLC, all that stuff. I'm not going to advise you on any of that because that's a CPA. A lot have to do with your CPA and your attorney. I can't give you advice on LLC, corporation, partnerships, okay? Creditors' right. If there's debts, co-owner's interest may be sold at execution of sale to satisfy any judgment and creditor. Same thing. Joint tenancy, if you are taking title with somebody that you don't know, which is absolutely not a good idea, but that means if you take title with somebody as joint tenancy, your interest is also at risk. So if I got a big lawsuit, guess what? My 2 sisters are liable too. Any questions? I see some questions. Why don't we answer that so they don't get confused any longer?
Okay.
And
so
then we still
now,
have a question and answer later.
well, the top question from Aini Tijua is asking, can you provide information on LLC ownership?
You know what? I'm going to, like I said, LLC is a different animal and your CPA sets up the LLC. And I think that's a CBA question because they do LLCs for one string. It's limited liability company, right? Or corporation. For investment property, a lot of people set up different LLCs. So if they get sued, only that property under that LLC gets the liability. So I have people that say, I set up an LLC, I put all my property in that. Why? They're going to sue the LLC, so all the property is going to be in with problem. I have a very rich investor. He owns like hotels and office building and da. Every property is under one LLC. Number one reason, he asked his attorney, his CPA advised him, if you have that ABC LLC, that LLC, somebody falls, somebody have a problem, they sue, only that LLC is liable, not the other one. So that's all I can say on LLC. talk to your CPA, talk to your attorney. And agent, do not suggest your client to do LLCs and all that stuff. If they want to do it, tell them to contact their CPA, their attorney. Number one is that agents, your job is to show property, get them the property, negotiate the contract, protect them with home warranty and title insurance and all that good stuff, but do not advise them on how, on LLCs or partnerships. I have something here on partnerships and things like that, but they need to talk to their CPA or their attorney or both. Okay. I'm going to talk about tenants in common now. Tenancy in common. Same thing. Any number. Yeah, let me answer this question for Kylene. If husband and wife hold title as joint tenancy, remember joint tenancy has a right of survivorship. If I pass away, I have a property with my husband. If I pass away, he gets the whole thing. That's what joint tenancy is. Okay?
Nancy, above, if you want to answer the questions now, about it above, Cheryl is asking, how about the property if before marriage is in a trust, will it become community property?
That's a gray area. Let me tell you why. If it's in a trust and it's your trust, right? Your trust. I'm not talking about your parents' trust. If you're the trust holder, okay? My understanding, but talk to the trust attorney, you should set up a separate, I think she's talking about investment property, not the house you live in with your husband or wife. Am I right? If it's an investment property, it's in a trust and your trust. Remember in California, the biggest mistake, the biggest problem that people sue is commingling of funds. You need to set up a separate account and his money or her money does never touch that account. It's your own money that belongs to the trust. If anybody sue or they want to take part of your property, attorney will use that as evidence. But are they going to win or lose? I have no idea, because like I said, everybody's financial situation, family dynamics different. I can't give you a definite answer, and nobody has a definite answer. It goes to court, it can go either way.
Yes, thank you. And another question there. It says, what happens when the property is sold under an incorrect vesting?
Oh, what do you mean sold? You mean you can?
That's what Charlene, maybe she needs to explain it further. I don't know.
Okay, let's say I think kind of guess. If I took title Nancy Chan, CHAN, and then I took title as joint tenancy, but I want to change my mind. I want to be tenants in common or community property. Both my husband and I can sign another deed, grant it to ourselves, and change the vesting. You can always do that and get it notarized and get it re-recorded, because things change. You want to change, like if you set up a trust, you want to grant it into a trust, husband and wife have a trust, you do another grantee and grant it into the trust. That's normal. It's not a big deal. If I read that question right, if my interpretation is correct. Okay, tenants in common, any number of people, any relationship will be tenants in common. Okay, if I'm married, my brother's married, we'll buy property not as joint tenant, right? It'll be tenants in common because I want to keep my own separate share. I don't want, if I die, he gets everything, right? So tenants in common is just any number of people, and the number of interests equal or unequal. That is the difference between tenants in common and joint tenancy. Joint tenancy, no matter how many people, the share has to be equal. Remember, 3 people is 1/3, 4 people is 1/4. But tenants in common could be different. Let's say I put more money into the property. I bought a property with my brother, and I pay more. I put more into the property, so I get a bigger share. So I buy it with him. Instead of 50-50, I want 70, he gets 30, right? I just closed a transaction that one of the tenants in common has only 1% because he didn't put any money down. He's just that, you know, they bought properties together. At that time, he didn't have any down payment. But I don't know what the situation is that one person got 1%. Okay, so any number of interests equal or unequal. You can be equal if you want. 1/3, 1/3, 1/3 can still be tenants in common or joint tenancy. All right, so nobody can say tenants in common never can have equal share. Yes, you can have equal share too. Equal rights of possession, and this happened. I got a really crazy phone call a few years ago. The brother and the brother bought a house. The older brother put more down payment in. Now he's married, and the new wife moved in. And now the new wife said, you cannot go into the kitchen because you didn't put in enough down payment. We give more. And the share that we have 70%, you only have 30%. It's like, why? I don't care if he has 1%. He has equal right of possession to go and in and out and use whatever he wants to use. You can't say you can only use that corner of the kitchen. You can only, I'm going to lock all the cabinets. You can't use them. It just doesn't happen. Okay. And that I started laughing, but it's not funny. It is not funny, but it is what it is.
What about the bathroom?
I know. It was crazy. You know what I mean? Can you make this brother-in-law go pee in the backyard? It doesn't make sense. So I just thought that was really ridiculous. And my advice to the agent, I said, if they need to sit down, get somebody in a, you know, like a mediator to get things resolved. I think finally the older brother bought him out. That's another good thing that it didn't turn out to go to lawsuit. Okay. Each co-owner's interest can be conveyed separately. Remember, tenants in common, you can grant it to anybody you want. You can put it in your trust. You can give it to your parents. It's fine. Okay. Because it's tenants in common, you have right to do whatever you want with your share. Okay. Let's say if Pauline, Sylvia and I owns a property together, we're tenants in common. Okay, but we like each other. We put equal money. So 1/3, 1/3, 1/3. If I die, it goes to my estate. So if my son doesn't want to sell or you guys don't want to buy him out, he becomes tenants in common with Pauline and Sylvia. But I trust you guys. He'll be in good hands. Okay, so my share does not go to you or Pauline. It goes to my heir. Okay. So the three of you becomes tenants in common. Only the co-owner's interest. If I have a problem with the lawsuit or whatever creditor, they can force me to sell. Or I can sell my own to satisfy that creditor, but only my 1/3. They can't touch yours. Okay, so that's pretty good. Any questions before I go on? I see there's one more. Is there one more question?
I think that one was answered earlier. Let's see. Okay, that's it. I think it's a new one.
Okay.
We as agents wouldn't suggest any type of it. When a married couple asks to make a quick comparison, what are the best short sentences that you would recommend?
Okay, I think new agent comes across this a lot because it's a brand new thing, all right? And they ask you, how should I take title? My thing is that give them my flyer. I mean, if you want the Chinese one, the Spanish one, whatever, give it to them. And then if you don't really want to explain, okay, just say what I say. Don't give them any recommendation. Explain the difference. But if you don't know how to explain the difference, come to the title company. Like if I explain to them, it's better than you explain to them. Because first of all, I'm a third party. I'm not pushing them into doing anything. I'm telling them the difference. But always at the end and the beginning, both times I would tell them, talk to your CPA, talk to your attorney if you really have questions. I'm not allowed to give you any suggestions. For any agent, that should be everything that you tell them that it's not your expertise. Financially, legally, always say that, okay? It's not a good idea for you to practice law when you don't have a law degree or a license to practice, or give them financial tax advice, because it does have a lot to do with their taxes too. That's why people do partnership, people do LLCs, because everybody's different. And even if they tell me all their financial things, I'm not qualified to do that. I still need my CPA to file my taxes, so I don't have all the knowledge. So it's not a good idea to give them a lot of advice. Okay. Any more questions on this? Sylvia, is there another one? Okay,
No,
good.
no other.
Partnership. People say partnership, they misuse this partnership so much. 3 people buy together as tenants in common, they say we're partners. No, you're not partners. Legally, you have to have a partnership agreement, okay? By your CPA or by an attorney, you are not a partnership just because you do something together with somebody. You're individuals. Partnership, thank you, Cindy. Partnership, you actually has to have a partnership agreement. So you can have any numbers of partners in the partnership. Let's say it's Apple partnership or whatever partnership, or Green Acres partnership. Partnership interest may be equal or unequal. Same thing like tenants in common. Some people put in more money. Some people is gonna do more on this property. So partnership also interest can be different. Okay, but the property has to be in a partnership. Just because Sylvia, Pauline, and I bought the property together, we're not partnership. We own the property together as tenants in common. We have to have a name of the partnership on title in the grantee to be called a partnership, okay? And we have to have a partnership agreement. And you have to have a general partner, like the president of a company. General partner can authorize to sign for the partnership. So that's why we need the partnership agreement. Title company, if you sell a property and we see it's a partnership, we will want a partnership agreement. We want to see who's the general partner. A lot of people, they do syndication, they buy property together. Let's say, I need $10 million to buy this project. So I set up a partnership. People can come in at different shares of the partnership, but they allow me, Nancy Chan, to be the general partner of the partnership. Then I'm the one that makes the decision I can sign. But in the partnership agreement, I have to give all the partner a notice and have them agree on it. I don't want 50, if it's a $10 million transaction, it could be 3 partners, it could be 10 partners, it could be 30 partners. 30 partners to sign is a lot of work. So, but they all need to be notified, give the general partner, which is Nancy Chan, to sign on their behalf. So just because you're general partner, we still want agreements from the partnerships, the partners. Okay, because I got somebody that yelled at me. They were selling a big property, and the general partners start yelling at me. I'm the one that authorized the sign, but says, yeah, I know, but you have partnership agreements say you need to get everybody to agree. You can't just sign and sell and buy anything you want to. Okay, and that's why when it comes to a trust, a LLC, a corporation, a partnership, we need the original partnership agreement. That's not recorded. People say, well, you're the title company. How come you can't find it? It's not a recorded document. You don't want people to know who all your partners are. You don't want to know financially how much money people put in. So that's not recorded. The property is only recorded under a partnership name. We need the underlying document. We need the partnership agreement. Okay? And we need an update saying everybody still said this partnership agreement is up to date and it's good. Okay? Partnership people, let's say there's 30 partners. They don't own the property. They own shares in that partnership. They own interests. They don't own the property. So I have people that yell to me, what do you mean I don't own the property? I'm part of the partnership. Yes, you own interest in that partnership. The property is owned by the whole partnership, that entity, not you. Okay, so You own interest. You don't own the property. So there's a lot of confusion when people say, I own the property. I'm 90% of the partnership. Yeah, but you don't own the property. Your partnership owns the property. You own 90% interest on that property. If I die, I own 50% of the partnership. My kids do not own the property. They own my 50% interest of that property. So let's say Sylvia and Pauline and I, we form a partnership and it's equal. We both put in 30, oh, that's 32, 30 what, 32.55, how many into the property? We only own 1/3 interest of the partnership. We do not each, none of us owns the property. Make sense? We just have interest in it. And because it's a partnership, we only can get the profit from that interest by percentage. We also pay the expenses according to the partnership agreement, according to the interest that we own, the shares that we own, okay? The percentage of interest that we own. And the partnership has one good thing. They can't touch, nobody can touch the property, even if somebody sues Nancy or they got a judgment over me. Only my profit from my 1/3 interest can be taken away, not the property. Just what I make from that partnership, the interest, the profit from that, my share of the interest, the 1/3 interest. If, let's say I make $1,000 a month from that, the partnership investment, they can only go after my 1,000. They can't even go after yours. So that's why I'm saying, don't tell your client how to do it. Tell them to ask their CPA attorney, how does the partnership work? And every project, when you set up a partnership, could be different. Okay, I have a couple questions. Pauline, you wanna see those questions? You can ask me the question now. You've been so quiet.
Sylvia can help you. Sylvia.
Yes.
Okay, Sylvia.
Okay. It says, can Nancy help us explaining what we should pay attention to when the title is under a trust during the transaction and under company's name too?
Okay. Anytime there's an entity, we call the partnership, the trust, the corporation, the LLC, entity, E-N-T-I-T-Y. They're entity-owned properties. Once I see a property profile that has a partnership name on it, a LLC name on it, or trust, individual and trust. I have one just now. I have to call somebody after 12 to talk about it. When we see this kind of stuff, okay, if you're the listing agent has more responsibility because you're helping the seller under a trust or partnership LLC to sell, right? Number one thing is when you order a property profile and you see the grantee under an entity, you're gonna talk to the seller, say, okay, it's under a trust, it's under a partnership. I need the LLC documents. I need the partnership agreement. I need the trust because these documents are not public record. They are private records. For example, let's say Nancy Chan has a trust, but I have a Picasso painting, or in Chinese, 我有张大千 painting in my house. That's worth a few $1 million. I don't have that, okay? But if I do, it's in my trust. The trust doesn't just have a property. The trust can have my 401k, my retirement, my bank account, my antique, my jewelry, all that, and my cars and whatever, all that could be in the trust. That's my estate, what I own. You don't want people to know that. If they know that I have a Picasso painting in my house, you think somebody's not going to break in and try to rob it or take it? Or they know I have 2 Rolex watches, which I don't because it's too dangerous not to wear them. But you don't put a lot of things into the trust. You just put everything, the property, into a trust. So I don't know who can sign for the trust. I've seen a trust that the grandmother set up. The grandson now is the successor of the trustee. But In the trust, there were like 5 properties. It happened, this one cannot be sold. This one is for them to just get the rent. So they cannot sell this one property. So if you're taking a list and they say they are the trustee, they can sell this property, I need to look at the trust. All the other 4 can be sold, but this one is worth a lot more. So the grandson was trying to sell it. The grandparents passed away. Successor of a trustee, his father passed away. He's the successor. He's the 3rd successor, and he's trying to sell this property. He can't, because the trust say you cannot sell this property. You can only rent it out, get money from it. Okay, so when you agent, ask for the LLC documents, ask for the partnership agreement, ask for the trust agreement, and also corporation LLC. We got to make sure they pay their taxes up to date. Any of the companies, the entity has to file taxes every year. And I've seen agent gets a listing, didn't talk to me, didn't ask for this, time to close, we go and enter the LLC and the corporation. They haven't paid their taxes in the last 3 years. That means what? The entity, the company is defunct. They don't exist anymore. They didn't file their taxes. So they have to hire a CPA, go back and file taxes and get it up to date so the corporation is in good standing. When they don't pay their taxes, it's not in good standing with the state of California, then we can't sell. Now we have COVID. Try to get that done takes a long time because the government departments are half closed. They don't respond as quickly, but that delayed the closing. And the buyer's agent was harassing my listing agent, not harassing, complaining, because they want to close. They have to move. Okay, so it caused a lot of last minute problems. So that's why I always tell the agents, my door is open. My phone is, you can text me, you can WeChat me, you can call me. When you get a listing, let's order a property profile so I know what's involved, and then I can give you advice what you need. Without looking at it, I don't know. But when it's under a trust, partnership, LLC, corporation, you need those documents. And I have one old lady, it was so funny. I told the agents to ask for it, and the son said, I have it. Okay, then what happens? The lady moved to Arizona. She took the whole box with her. So now she says, I just moved here. I don't know where the box is. I know I have it. The son says he had a copy, but he didn't have a copy. The old lady was 92 years old in Arizona, try to go through her stuff and look through for the trust. You know, that was, but the son was nice. He drove to Arizona and helped her look. But I don't expect an 80-year-old, 90-year-old to be able to find something right away. So if the old lady is selling a property under a trust, number one thing, can you find your trust? Where is it? Do you remember? Give her plenty of time to look for it. Don't wait till when we ask you for it. Then we put it in the prelim, but most people don't look at it. Guess what? You didn't give it to me, and then you were supposed to close. Today is Tuesday. You want to close on Friday. Sorry, Sylvia, you can't close. I need the trust. Okay, especially when the original trustee passed away. We really, really need to look at the trust. Okay, so let's talk about the trust. I think our time is almost up. We got 5 minutes. Trust, there's beneficiary, there's trustee. Beneficiary interest can be equal or unequal. The property is not owned by the person anymore. That person that set up the trust will be the trustee of the trust. Okay, so the grantee will say Nancy Chan, trustee of the Nancy Chan Revocable Living Trust, and the date when the trust was set up. So everything we look at, how we took title, how to disperse the trust, how much interest in there, it's all according to the trust agreement. Okay? And the trust agreement, if I die, the trust agreement would tell how to disperse the money when we sell the property. Otherwise, the escrow doesn't know who gets the money. All right? So I think most of the creditor, they don't go after trust, but they can go after they can go after the trust, but they can not go after the beneficiary. So a thing about the trust is that you have to understand, without the trust agreement, we really don't know what the trust want us to do. So please get all the documents ahead of time. I'm sorry I took a long time. Any more questions? I'll give you 5 minutes and we're done.
Yes, we have a question here. Let's see. She said she was going back to the question earlier. Let's see, where is that? Let me look at it. Hang on one second. Okay. Going back to the question, what if the seller's vesting on the deed was incorrect? Now the property is sold. Is there anything the seller can do at this time?
I think we need to talk in private, okay? My phone number is 626-318-8897. Call me, because that could be a very long conversation. I'm thinking already. I know what's going on.
And then another one here by Patty Shane. For death, what's the difference between survivorship and joint tenancy?
Oh, joint tenancy and survivorship are the same. That means when one person died, the other person gets it. But survivorship, it's joint tenants automatically have survivorship. Husband and wife, both, they either take it as joint tenancy or community property with a right of survivorship. But if they take title, not under these two, they take title under community property, they only get 1/2 of the person that died, not the whole thing. Okay, joint tenancy, they get all your share. Community property, right of survivorship, somebody dies, they get all your share. But community property, you only get 1/2 of what the other person, the person that died.
Okay, we have a couple of questions here. Can sister and brother in title consider a property transfer? Does
What?
this, I don't understand the question. Transfer, does this adding a person in the title cause property tax increase? What kind of fees?
Right now, okay. Proposition 19 just passed. That's another whole big story. But right now, any change of ownership can cause an increase of property tax, except for husband and wife. Adding a spouse on title will not trigger a reassessment. If you put it into a partnership, LLC, or trust, if the shares and the interest are the same as before, husband and wife change to a trust of their own trust, it's not going to trigger a reassessment. If you form a partnership, 3 people, they each have 1/3. They form a partnership, also 1/3, 1/3, 1/3. The county will ask for your partnership agreement, and then they'll chat. If there's any difference in partnership, okay, LLC, this is what happened. Even before Proposition 19, husband and wife owns a property. They want to grant to an LLC. Guess what? The LLC doesn't have the husband's name. It triggers a reassessment. It's not the same party, no, not the same share.
Okay, one last question here. What do you suggest if a loan paid off over 10 years ago but did not record the recon? Now there's a cloud of title. What can the borrower do?
The borrower can go, and we can find these lenders, unless they're a private lender. Most lender, even if the bank doesn't exist anymore, some other people took care of them. Like Countrywide, Bank of America, WAMU, Washington Mutual is also Bank of America. We can find them, but it takes time. And if it's a private person, then there's several bonding company that you can pay for a bond, and then they could record a bond on the property that would take care of that cloud. But every case is different. So talk to me. I've been doing this for a long time, 39 years. It's a lot of fun, but there's a lot of questions too. All right, go ahead. Anything else? Then
That's
my
it.
phone.
That's
Okay.
all the questions we have.
My phone number is on my bio. Call
Yes.
me. Give me half an hour. If you want to call me, ask me question half an hour. I got a few phone calls to get to. Thank you, Sylvia. Thank you, Fong.
Very much, Nancy.
Thank you, Fong. I love all of you. Thank you.
Thank you. Thank you
I'm
so
on the
much,
list.
Nancy
Go.
and
Mhm.
Sylvia, for this wonderful section. If you have any further question regarding title vesting, go contact to Nancy Chan directly, and she will answer all your questions and fulfill your escrow or your prepare work Very well. On behalf of Western Gateview Valley Realtors, we would like to thank again Nancy Chen, lawyer's title, for your expertise and valuable presentation today to us. We hope to see you in person very soon. Our next 2 classes will be next Monday, March 22nd, 11 o'clock. Don't miss out if you want to know trust estate planning. This topic will be common estate planning mistake by attorney Paul Velasco from Velasco Law Group. And next Tuesday, March 23rd, 11 o'clock, we have a good class for you, Power of Preparedness by Connie Mayers. Please register all the classes at wsgvar.com. Click the education schedule to register all the classes and learn together. Thank you, Nancy, Sylvia, Fang, and all of you joining today's class. We'll see you next Monday, 11 o'clock.